Hello, future lawyers. Welcome back to our new video. In civil law, not all marriages are created equal. Some are valid and binding for life, while others are void from the very beginning or are voidable by law. In this video, we will break down Articles 35 to 45 of the Family Code of the Philippines on this topic. Let's get started. Article 1 of the Family Code states that marriage is a special contract of permanent union between a man and a woman entered into in accordance with law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. Marriage has essential and formal requisites under Article 2. The essential requisites of marriage are 1. Legal capacity of the contracting parties, who must be a male and a female, and 2. Consent of the contracting parties, freely given in the presence of a solemnizing officer. The formal requisites under Article 3 are 1. Authority of the solemnizing officer, subject to Article 35, a valid marriage license, subject to exceptions, and a marriage ceremony. Article 35. Marriages void from the beginning. So, void marriages include 1. When either or both parties are under 18 years of age, even with parental consent. 2. It was solemnized by a person not legally authorized to perform marriages unless at least one of the parties believed in good faith that the solemnizing officer had authority. 3. Without a marriage license. 4. Bigamous or polygamous marriage, except under Article 41. And 5. Mistake of one party as to the identity of the other. Note that polygamous or bigamous marriages are void except where Article 41 applies. Article 41 allows remarriage if one spouse has been absent for 4 consecutive years or 2 years in specific instances, such as danger of death situations, and is declared presumptively dead by a competent court. The degree of diligence in locating the whereabouts of a missing spouse must be strictly complied with in view of the summary nature of proceedings under Article 41 for the declaration of presumptive death of a missing spouse. Article 36 of the Family Code provides that a marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. In the case of Marcus versus Marcus, the Supreme Court declared that a medical examination of the person concerned need not be resorted to. Instead, as this court said, the totality of evidence presented is enough to sustain a finding of psychological incapacity. In Tan Andal versus Andal, May 2021, the court held that the psychological incapacity contemplated in Article 36 of the Family Code is incurable not in the medical but in the legal sense. This means that the incapacity is so enduring and persistent with respect to a specific partner and contemplates a situation where the couple's respective personality structures are so incompatible and antagonistic that the only result of the union would be the inevitable and irreparable breakdown of the marriage. Article 37. Incestuous marriages. Marriages between the following are considered incestuous and are therefore void ab initio. Number 1, between ascendants and descendants of any degree, legitimate or illegitimate, and between brothers and sisters, whether of full blood or half blood, legitimate or illegitimate. Article 38. Void marriages due to public policy. Marriages between the following are considered against public policy and are therefore void ab initio. 1. Between collateral blood relatives within the fourth civil degree, such as first cousins. 2, between step parents and stepchildren. 3, between parents in law and the children in law. Between adopting parent and adopted child. Between the surviving spouse of the adopting parent and the adopted child. Between the surviving spouse of the adopted child and the adoptor. Between an adopted child and a legitimate child of the adopter. Between adopted children of the same adoptor. Between parties where one, with the intention to marry the other, killed the other person's spouse or his or her own spouse. Voidable marriages. Article 4 of the Family Code states that a defect in any of the essential requisites that render the marriage voidable, as provided for in Article 45. Voidable marriages are valid until annulled by a court due to defects in consent, age, or incapacity. Grounds are specified in Articles 45 and 46 of the Family Code. Now let's go to voidable marriages. These are marriages that are valid until annulled or until voided by a competent court. And the following are the grounds under Article 45 of the Family Code. 1. The party in whose behalf it is sought to have the marriage annulled was 18 years of age or over, but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party, in that order, unless, after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. 2. Either party was of unsound mind unless such party, after coming to reason, freely cohabited with the other as husband and wife. 3. The consent of either party was obtained by fraud unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. A marriage is likewise voidable when the consent of either party was obtained by force, intimidation, or undue influence, unless, the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. When either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable, or either party was afflicted with a sexually transmissible disease found to be serious or appears to be incurable. Article 46. Any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. 1. Non disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. 2. Concealment by the wife of the fact that at the time of the marriage she was pregnant by a man other than her husband. 3. Concealment of sexually transmissible disease, regardless of its nature, existing at the time of marriage, or concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of marriage. And we're done. In conclusion, a void marriage was never valid from the start. They are invalid ab initio as if no marriage ever existed. On the other hand, avoidable marriage exists until annulled by a final judgment. These are marriages which are presumed valid and produce legal effects until annulled by a final judgment. And thank you so much for watching. I wish you all the best, and you may subscribe if you like to. Have a nice day. Bye.